you are live, Andreas, but I see some attendees still rolling in, so maybe give it a minute while all the attendees join and kick off.
Sounds good. We'll give it one more minute before we start.
I think so.
Okay. Mike, while we wait for the last stragglers to come online, introduction of the panel. I know we have a
Is it only me or is Andreas frozen?
Andreas, I think just turn your camera off for a second. We've lost you there for a moment.
PDF that when everybody saw that be remarkable.
Apologies, Andreas, we lost you there for a while.
Apologies, I don't know what that was. I think we have everybody on now. I was hoping we could get some sort of introductory remarks from you in between while we were waiting for the last stragglers to come online. But if you can all hear me now, let's get going. I think it is a couple of minutes after our official start time. Welcome everyone to the Primerio hosted panel on trade remedies with a focus on Africa. We are excited to have you here, and we're excited to have a great panel consisting of a really interesting variety of experts on this topic, from academia to down on the ground dealing with daily trade issues, to practitioners in the legal field, as well as government and quasi/regional body enforcer representatives. We are going to kick it off with a short introduction by the panel of themselves. And I would ask that everyone mute themselves when they're not speaking, just as a reminder. And let's get going with our experts, with our panelists. Vasilis.
Thank you very much, Andreas. Ladies and gentlemen, great to be here before a distinguished audience and a great panel of experts. My name is Vasilis Akritidis. I am a lawyer of Greek origin that lives in Brussels for the last 35 years. And I'm a partner at the American law firm Crowell and Mooring in their Brussels office. I'm heading the international trade team for Europe. And trade defense, trade remedies is what I do for more than 25 years now. Thank you.
Thank you. Professor Erasmus.
Good afternoon, everybody. My name is Gerard Erasmus. I was informed only yesterday that I have to stand in for Trudy, so if you are disappointed to see me here, I'm not responsible for that. I am an academic, although I have taken early retirement from the University of Stellenbosch in 2005 already. I'm an associate of Tralac. I also have the responsibility for having started that outfit. I work with Trudy Hutzenberg in the normal work that we do at Tralac, which is research, training, publications, and from time to time we do more applied work, draft legislation, we do legal opinions, policy work, and so on. That's where I come from. I have been involved in some of the negotiations with the AfCFTA, and I am responsible this afternoon for saying a few words about the architecture of this continental agreement and some of the specifics on trade remedies and safeguards. Thank you.
Thanks, Professor. Next up is Tuto.
Thank you, Andreas. Good afternoon, everyone. My name is Tuto Mateta. I am from the Southern African Customs Union Secretariat, in short, SACU. Essentially, my role there is to provide support to the member states of SACU in respect of tariff and trade remedy related changes. Thank you.
Thank you. And we have your Southern/Eastern counterpart from COMESA here as well. Alice, will you introduce yourself, please?
Thank you very much and good afternoon. My name is Alice Twizeye. I'm a senior trade officer at the COMESA Secretariat, which is the common market for Eastern and Southern African markets, ranging from North, East, and South African region. I have an extensive experience in trade-related issues for over than 15 years now. Thank you very much.
Thanks, Alice. Peter O'Brien.
Sorry, it's not. Can you hear me?
Yes, we can.
Good. Good afternoon, ladies and gentlemen. I'm delighted to be with this great panel and also with the audience. I'm an Irish and Spanish national with a base in Brussels. I have worked originally for the United Nations on trade and development with a huge amount of work in Africa, followed by being the chief economist for what was then Dupont de Nemours for Europe and for Africa. I've been engaged in most of the regional negotiations through Africa, both in Southern and Eastern Africa and in the Western African communities, as well as doing a great deal of negotiations with those groups inside WTO. And as a Spanish national, it's also been my privilege to negotiate the Spanish entry into the European Union. Thank you very much.
Thanks, Peter. Next up is Craig.
Thank you very much, Andreas. My name is Craig Buyonge, and I'm from Kenya. That's why you see the Kenyan flag behind me. I have a background in customs, policy and administration, but for the last 11 years or so, I've been working as a consultant on customs, international trade, trade facilitation, border management. And I'm happy to be talking about customs valuation and trade disputes in Africa. Thank you.
Thank you, Craig. It's a lovely flag. It's one of the best looking flags I've ever seen. And last but not least, my colleague, Michael James. Mike.
Thank you, Andreas, and hello everyone and welcome. Listening to the very brief introductions, I'm not sure if 90 minutes is enough for this conversation, but I'm a director at Primerio based in South Africa and practice principally in regulatory law with a focus on antitrust competition law across the continent. So yeah, welcome everyone and look forward to the discussion.
Thanks, Mike. We will not delay any further and we'll get into the substance of things just so that the audience knows. I always like to know when I'm an audience member what awaits me. Our plan is to have short, about 5 or 6 minute substantive presentations by each of the panelists in the same order that they just introduced themselves. And thereafter, it will be somewhat of an open round of discussion and sort of playing the ball back and forth based on what was said. Again, the topic overall is trade remedies with the view on how international trade administrations and firms can better understand the circumstances in which these trade remedies might be applied against them. We start off, for those among us in the audience also who are perhaps somewhat new to the field, with a more fundamental explanation coming from Vasilis. Please, Vasilis, go ahead.
Thank you, Andreas. So as Andreas said, I'm probably the guy of down on the ground practitioner. I'm a lawyer. I represent parties in trade defense investigations for a few decades now. I have done about a bit more than 100 investigations in several jurisdictions. I'm based in Brussels, so my experience is primarily with the EU regime, but I have represented parties before the Department of Commerce in Washington, before the Eurasian Economic Commission in Moscow, before the Brazilian authority, the Turkish authority, the Pakistani or the Chinese authority. And invariably, the rules are more or less the same everywhere. So what is trade defense? Trade defense, and apologies to those in the audience who are already very familiar with the topic, but just to set the framework straight, the legal basis is common for all WTO members. It's the anti-dumping agreement, which was concluded among WTO members in the end of the Uruguay round. The ADA. The ADA has pushed things forward dramatically worldwide. It has provided a comprehensive set of common rules to which WTO members have to comply. So in other words, WTO members are free to adopt their own laws and administrative regulations insofar as those are not in conflict with the 3 WTO agreements on trade remedies. And these are the anti-dumping agreements, the agreement on countervailing measures, subsidies and countervailing measures, and the agreement on safeguards. These are the 3 forms of trade defense that apply worldwide. Anti-dumping being by far the most commonly and frequently used. To counteract, permit me to say, unfair trading practices, as this is the rationale behind it. And what is unfair? Unfair, according to the anti-dumping logic, is when an exporter exports goods at a price which is lower in the country of destination, lower than the country of origin, the home market. This is when dumping occurs. Anti-subsidy, subsidies and countervailing measures counteract certain subsidies which the relevant WTO agreement and national legislation find to be incompatible with the WTO regime. And I'm saying incompatible and not illegal because dumping and subsidies basically are not an illegal practice. It's a practice that theoretically, at least, Peter O'Brien will have perhaps a different view because economists are not very fond of anti-dumping, not always at least, which distort competition. So it's a sort of an international unfair competition, tackling unfair competition. This with regard to the 2 most commonly used measures, anti-dumping and countervailing duties to counteract subsidies. When it comes to safeguards, safeguards are actually what the name says. It's a last-ditch resort, unilateral action, erga omnes, against everyone, while anti-dumping and countervailing duty investigations are targeted against specific countries, specific origins, and within these origins against specific companies, while a safeguard raises a uniform wall on all imports, irrespective of origin. In this sense, there are significant commonalities in the legal regimes and the argumentation and the remedies and the way that anti-dumping and trade remedy rules and duties and measures are imposed worldwide. In a nutshell, I would say that these three types of measures are the three permissible under the WTO regime forms of unilateral trade action. This means that while a WTO member cannot impose arbitrarily new customs duties, conventional customs duties on imports, which violate that WTO member's schedule of commitments before the other trading partners in Geneva, before the WTO. You know that every country submits a schedule of commitments to which it must adhere. But what happens when you suffer, your domestic industries suffer from imports which are either unfairly priced, very low priced, or subsidized upon exportation, or just flooding your market, creating conditions of serious injury, like in the case of safeguards. In such events, then you are allowed, the WTO allows you to take unilateral action, which otherwise is not permissible. We will speak later about remedies. Suffice to say, I would only like to raise an important parameter in WTO law and practice, which is that although the WTO lacks an enforcement mechanism, it does have an indirect enforcement mechanism, in the sense that when a WTO member violates the rules, then those that suffer from this violation can go to Geneva and ask permission for retaliation. And once this permission is given, you will have seen this happening. I'll give you a very well-known example, the long dispute between the US and the EU on subsidies on aircrafts, the Boeing Airbus case. Whenever one of the two parties does not comply with the WTO ruling, then the other may take countermeasures, may retaliate. So indirectly, there is a mechanism to enforce this regime worldwide. I think that's a very general introduction on what trade remedies are. We are going through times of quite challenging times after COVID. Now we have a crisis in raw materials, crisis in transport and in energy. What we see is a surge of trade actions because, of course, from these events, domestic industries suffer injury, and they seek protection from regulators, a few of which in the African continent we have in the panel. Thank you very much for your attention. I'll be happy to take any questions on the practical aspects of these investigations. As I said, I am a practitioner. I have been active both in the offense game of trade remedies, so acting for petitioners, and also in the defense, acting for exporters before various jurisdictions. I also have quite a lengthy experience in WTO matters. I was part of the team that helped the Russian Federation to accede to the WTO. We have been involved in all with the chief negotiator of Russia in the negotiations with other trading partners in Geneva. So, I am aware of the issues. I'll be more than happy to take questions. Thank you very much.
Thanks, Vasilis. I think that was an excellent introduction. And for someone like me, who's really more of a competition antitrust practitioner and is not, like you, a trade law expert, it gave a great overview. I thought it was fascinating what you said about the enforcement mechanism, that really, if you had to put an analogy on this, it's really just a big playground where all the kids are playing. And if somebody throws sand in the other's face, there's only one parent in the playground, and that parent doesn't actually enforce anything. It's just that the other kid can come to the parent and say, am I allowed to throw sand back at the other kid now? And the parent either says yes or no, and then it's a sand throwing fight. So that sounds rather medieval to me, but I'm only the moderator here and I'm not the expert. But let's get going on the AfCFTA. Professor Gerhard Erasmus, if you can give us a little taste of what the free trade agreement that is in its nascent stage across the African continent looks like and what it is meant to accomplish, we would be grateful. Professor.
Thank you. The AfCFTA, the African Continental Free Trade Agreement, is officially in force, but no trade is taking place under this agreement. It entered into force at the end of May in 2019 when the required number of ratifications were deposited. But the reason for the fact that no trade in goods and also not in services is taking place is because outstanding negotiations on tariff schedules and rules of origin must still be completed. Why is it taking so long? Well, if 54 countries have to conclude one single legal regime for preferential trade in goods and some services, and those countries come from very different backgrounds, and they are from different stages of economic development, then it is bound to be a complicated exercise. When will the outstanding matters be finalized? We hope that it will be by the end of the year. If that does happen, what is then going to be the position? A very important feature of the AfCFTA is that it is not suspending or moving the regional economic communities off the chart. So the AfCFTA is going to exist alongside the regional economic community free trade areas that we have, and also the customs unions that we have. SACU, Southern African Customs Union, and we're going to hear more about it, is claimed to be the world's oldest functioning customs union. It predates decolonization and the establishment of the REX. So important to emphasize that the AfCFTA is ambitious, but it is not a customs union. It is a free trade area agreement, which has a very specific architecture. And I call that architecture the architecture of parallelism. So who will then ultimately engage in preferential trade in goods once all the outstanding building blocks are complete? It will be those member states of the African Union that have ratified this agreement. They are referred to as the state parties, and they count about 38, 39 at this moment. Those of them that have not, or that are not in the same regional free trade arrangements, in other words, those that have been trading with each other up till now under MFN, WTO rates, they will now have at their disposal a preferential trade agreement. So to give you an example, there's no preferential trade agreement between SACU on the one hand, which includes South Africa, and Nigeria. So once this agreement is finally operational, then it will be possible for importers, exporters between the SACU area and Nigeria to trade with each other under preferential rates. Now, of course, trade agreements don't create trade, but that is what the legal context will provide. Finally, the fact that the regional economic communities in SACU and other trade arrangements continue to exist. As a matter of fact, there are provisions in the AfCFTA agreement saying that the state parties shall remain members of those existing arrangements and shall advance their agendas. So these things, these arrangements are going to run parallel to each other. That's important to remember. And then if we later on take a look at what is in the AfCFTA agreement on trade remedies and safeguards, I can just mention there are 4 provisions in the main agreement. By the way, this AfCFTA agreement is detailed. We've got the founding agreement, and then we have the 3 protocols of phase 1. At the moment, 3 protocols of phase 2 are being negotiated. The phase 1 protocols are the protocols on trade in goods, trade and services, and dispute settlement. And then the protocols have their own annexes, and in some cases, the annexes have appendices. All of this together constitute an integral single agreement. In the case of trade remedies and safeguards, we've got a detailed annex, Annex 9, and there's also a set of guidelines on how to apply the Annex 9. Those guidelines have not yet been completed, and there's the yellow hand. Thank you.
Thank you, Professor. That was a great overview. The reference to the yellow hand, by the way, for our audience members is simply, I don't know if they can see it. It's nothing magical or mythical or trade law related. It's simply my raising my virtual hand to let everybody know that their 5 minutes are coming to an end. But no need to, if the panelists are in the middle of something important they want to say, there's no need to suddenly stop. But I think we were at a good caesura there, at a good transition point. Thank you, Professor. Fascinating. It seems extremely complicated. An appendix to an exhibit to to another appendix sounds like a lot of documents to be aware of. And I think it was a fascinating example that you gave, the example of South Africa or SACU and Nigeria. To my knowledge, South Africa and Nigeria are the two largest economies on the African continent by volume, by GDP. So to have those two in one free trade area is quite a feat. And let's see where this goes. I know you said it is technically operational, but nothing has really been traded yet under the auspices of the AfCFTA. Let's see where we go with it, and I'm sure we'll discuss that during the course of the seminar, and then of course over the next few years when things will actually become fully operational and are being used, and there will be disputes likely. Now, if I can move to our friends Tuto and Alice, both of whom are somewhat in the same boat and represent some of these larger trading blocks, to discuss the use that is currently made of existing schemes and trade remedies. So the regional groupings here are the southern and the COMESA, the SACU and the COMESA area. Tuto, why don't we start with you?
All right, thank you, Andreas. I think Vasilis has laid down a good foundation for the concepts, the context within which we are speaking today. Professor touched a little bit also on SACU, that it's an oldest customs union. So I just want to maybe take a few seconds to just introduce to everyone a little bit about SACU, just so that we'll understand the context within which trade remedies in SACU are applying. So being a customs union, SACU has a common external tariff among the 5 member states, Botswana, Eswatini, Lesotho, Namibia, and South Africa. And so it also has a number of institutions for governance, on the top being the SACU Summit of Heads of State and Government. I don't want to specify all the institutions, but just to pick up certain strategic ones. We also have the Council of Ministers that is pretty much responsible for most of the decision making in SACU. And then one institution of interest, I believe, will be, in accordance with the agreement, the so-called Tariff Board, which is, in terms of the agreement, has been provided for. Then the understanding is that member states will also be required to have their own national bodies, which are responsible for doing preliminary investigations on tariffs and trade remedies, who will then submit their recommendations to the tariff board, which will then make recommendations to the council on the level and changes, including on trade remedies. But the reality today is that we don't have the tariff board operational as yet. And a decision was made by the Council to have the International Trade Administration Commission of South Africa, IATEC, to perform the role of the tariff board until the tariff board is operational. So most of the work is happening in IATEC, working together with the Secretariat now to coordinate all the necessary processes at regional level. I think what will come out clearly is that now, for the fact that we are dealing with more than one countries which are sharing a common external tariff. Clearly, it means that all the submissions have to be well coordinated from all the member states. Perhaps for example, applications for investigations or certain alleged injuries that may be happening that could require anti-dumping or safeguard measures or countervailing measures. So there's a process that has been established to ensure that all the stakeholders are participating in the customs union. So clearly, some of the issues that will come will also include the issue of capacity in the private sector. Is everyone able to raise sound requests for investigations, for example, and also to respond adequately when there have been applications by others, and so on. So these are some of the issues that arise. Processes are usually also time-bound, and therefore there is need to ensure that all of these processes take place within time to ensure that any necessary measures are put in place within time. And remembering that the target is to try and protect domestic industry in most cases. So there has to be action that takes place in time. So this is pretty much the situation that we're in. I believe that we'll have more chance to expand on some of these things. If that is okay with you, Andreas, then I can pause here. Thank you.
Thank you very much. Can we move to the COMESA region, Alice, and can you give us your take on it? It may be very similar to what Tuto just described, but I assume that you have a slightly different view of things, given that you are focused on a different and I think much larger in terms of the number of member states. That's my alarm for the 5 minutes. Tuto, you were under the 5 minutes. Very good. As I said, Alice, your membership is much larger in terms of the number of member states within COMESA, if I'm not mistaken. So perhaps that has an effect on the trade architecture that you are faced with. And also, can I just ask everyone to just mute themselves? I think Peter is unmuted. Go ahead, Alice. You have the floor.
Thank you very much, Andreas, and thanks to all previous speakers who have already set the ground for me. So just to start where you just ended, Andreas, I just want to say that to introduce the organization which I'm representing, COMESA Secretariat. The COMESA region has a membership of 21 member states, ranging from North, East, and South Africa markets. So all the membership are available on the COMESA website. To say, we in COMESA, we are implementing a free trade area since 2000, and currently out of the 21 member states, 16 of them are fully implementing the free trade area. And the remaining 5 are at different stage of implementing the free trade area. In terms of trade remedies, as you will all agree with me, the WTO is, I may say, the mother law in terms of rights building. The treaty establishing COMESA free trade area under its Chapter 6 states the cooperation, trade, liberalization, and development. And also it has a number of articles through that Chapter 6, which articulates on different areas of trade liberalization, including the trade remedies, especially Article 51 all the way to 54. And then Article 61, which specifically articulate on the safeguard clause. Beyond that, apart from the treaty, we have regulations on trade remedies, and the regulations, of course, stipulates more details on how the trade remedies should be applied. In a nutshell, the trade remedies, especially in the application, states that if a member states would want to apply, then it should be 1 year, within 1 year. However, it can be extended to 4 years as an initial period. Later in the regulations also provides a possibility for extension up to 8 years of such safeguard or dumping or countervailing measures. So that is in a nutshell what the regulations and the treaty says. However, I just want to share one case, at least during my, I should also mention that, by the way, I only have 1 year and 4-month experience in COMESA Secretariat, but of course, I come from Rwanda, which is a founding member of COMESA, and I've been working, as I said before, in trade areas for the last more than 15 years now. So one experience, at least during this my period in the Secretariat, we have one case of safeguard, which has actually now lasted for 19 years, as being extended upon request and extension by the council, which actually make a decision upon such a request. However, there are some challenges, I think, which were highlighted by some of my colleagues, my previous colleague, to say, like capacity and institutional framework in terms of application of those safeguard measures and trade remedies in general. So we only have among the member states, Egypt, which has a fully constituted framework. So I believe that we'll have more opportunity probably to share such experience. I think I should just pause from here, and thank you very much for your kind attention. Thank you.
Thank you, Alice. We appreciate that insight. I know from my experience of being on a group that communicates regularly within the COMESA business journalist community, that there are lots of small spats, if you will, regarding basic necessities such as milk or flour or sugar between COMESA member states, right? And I think that is all part of what you deal with on a possibly day-to-day basis, between Uganda and Kenya, et cetera. There are lots of sort of protectionist measures that one reads about in the press. And perhaps we can get into an example there later, whether or not COMESA steps into these disputes when, let's say, Uganda blocks the import of cheap Kenyan milk or vice versa, or whether COMESA waits until there's a complaint filed. We are moving on to our friend Peter O'Brien, and I have to actually pull up. Peter, why don't you introduce your own topic regarding the impact of rules and the concept of trade and the concept of a market. As an economist, I think you are uniquely qualified to speak on those topics.
Thanks, Andreas. Thanks to the previous speakers as well, who I think have given us a terrific start. I want to tackle very quickly, contextualize things, if I may, with 4 core points. The first is just to get a quick sense of where we are with trade in Africa. If you just look at intra-trade among African countries as a share of global trade, then if you measure it by exports, intra-African trade's about 1/6. If you measure it by imports, it's roughly 1/5. If we ask ourselves, what does regional trade within Africa function as a share of all African trade, then taking 2 or 3 of the main regional blocks, we could say that we're talking somewhere around 50% for COMESA and for SACU. For SADC, it's much higher figure, closer to 90%. So Southern and Eastern African trading blocks are in that sense relatively well integrated. If you look across West Africa, in general, there's a whole variety of trade blocks, but most of them are running at lower shares than I've just mentioned, except for ECOWAS, which of course includes some very big countries, and that too is running a bit over 50%. What's the African intra-trade look like compared with the rest of the world? Again, just to give ourselves a sense of where we are. Well, it's certainly lower than for the EU, and it's also lower than for what is now called the US-Mexico-Canada agreement, it used to be called NAFTA. But it's a bit higher than ASEAN, and still we've got a relatively stillborn operation in terms of the comprehensive and progressive trade partnership in Pacific. It's also a lot higher in Africa than it is for the Latin American countries. There's a couple of other things I think we need to keep in mind, which I think do have an influence on what's happening here in terms of trade and trade remedies. One of them is that unlike, say, the European Union and the United States, Mexico, Canada, there's very little regional value-added chains in Africa. Very little. It's starting to develop, but it's still small. Finally, we need to keep in mind that in Africa, there's also a situation where there's quite a lot of informal trade and quite a lot of illicit trade. That doesn't get measured too easily, but it needs to be kept in mind. And I'm sure that some of our other colleagues who are working on customs issues and so on can give us a better idea there. Second core point I want to mention very quickly is just corporate presence. Still, to the best of my knowledge, there are relatively few what we could call indigenous African firms which are operating with presence in several different African countries. The number's growing, and in certain sectors it seems to be growing pretty fast, especially in somewhat technologically advanced areas. In this sense, I think a number of African countries, especially in Southern and Eastern Africa, are managing to, as it were, jump the chasm very quickly and make a lot of advance in terms of technologically advanced operations, like in some of the service areas, in payments and so on and so forth. These companies, my quick guess would be, looking a little bit towards the short, medium-term future, but this is for everybody to comment on, that these groups would probably not be, let's say, so concerned themselves with trade remedies as such, but they might be very, very concerned about some other aspects of the law, and I'm sure we can come back to that. Third main point I want to do now is move immediately towards liberalization and liberalization with rules, which is what we've been doing ever since WTO and even long before, liberalization with rules. One of the things that I always notice when groupings and countries are trying to, as it were, open up to trade, caution is always a watchword. People want to move, but not too quickly. And they also want the opportunity to be able to put on the brakes a bit if they need to. Now, the rules are usually characterized by three things, which I think Professor Rasmus in particular has made very, very clear to us. These rules tend to be substantial and very complex. Second characteristic is that they are frequently filled with all sorts of clauses that allow for exceptions of one kind or another. And thirdly, the rules are quite often tricky to interpret. So in short, it's a perfect field day for lawyers. Okay. When the brakes come into controlling trade, as Vasilis told us at the beginning, we're looking in particular at anti-dumping. We're looking at so-called SCM, which is really the measures where you have subsidies and countermeasures, and we're looking at safeguards. And these operate in certain respects, as Vasilis mentioned, in the same way, but also in somewhat different ways. They are the steps which are taken by individual countries, and they're also the steps which are taken by the EU as a trading bloc, a very powerful trading bloc. Why? Because all of trade policy, of course, is centrally managed by the EU. We have dispute resolution mechanisms because these rules have to be handled. So to try and run quickly on some other points, I'll just say that I've been looking at the numbers for WTO about how the dispute resolution mechanism is working, and I can say that actually the numbers of disputes are pretty low, mainly a few dozen for the anti-dumping and the countervailing measures. A few countries and a few products seem to be the main ones. African countries have made very, very little use of these provisions on the whole. I think that's important to notice. Maybe with time, Andreas, I notice you put up the flag. I'll come back with some further points as we go.
Thank you, Peter. I think you truly raised several points that I'm sure other panelists will want to comment on later. Fascinating numbers regarding the intra-trading block figures, the percentages that you mentioned earlier, the volume. Interesting that Southern and Eastern Africa have a fairly high sort of success rate, if you will. I'm sure that's not the right term, but a high degree of making use of their trading blocks. When it comes to West Africa, not so much. One thing that I will just comment on now, and we will, I'm sure, take this up as we go into the open round shortly after Mike gives his presentation, is I'm fascinated by the fact that, you know, the EU has been mentioned quite a few times. Nobody has mentioned China. I find that very interesting because we are all aware that China is somewhat an elephant in the African room, so to speak, in the African house. And there's a battle for, you know, everything from manpower to, of course, resources and the access to the sale of goods and services and those large, vast markets in Africa. And that battle is being fought largely by China, with the United States and the EU, I think, lagging behind. So I'm curious to hear from everyone later what they think about trade remedies and how China plays into this. But next up is Michael James discussing free trade policy and protectionist measures.
Thank you, Andreas. So I think what I wanted to focus on in particular was competition law in trade agreements or in free trade protocols, and really two elements to it. The one being competition law in free trade agreements generally, and the other is the policy behind competition law, which is likely to give rise to trade disputes in the first instance. And time permitting, I'll get back to the first one. So I want to focus on the second one, because you asked about protectionism. And certainly from a South African perspective, South Africa being the lodestar on the African continent from a competition enforcement perspective, a significant market, and also not only a member state to, as we said, SACU, but also BRICS, and will be a prominent player in the negotiations to the African Continental Free Trade Agreement. And we know phase 2 of AfCFTA relates to competition policy negotiations. So looking at the influence that South Africa's competition law policy is going to have, or potentially going to have, both in shaping AfCFTA's trade policies and also potentially giving rise to greater disputes, I think is highly important and something which needs to be dealt with and discussed and debated at length up front. And I want to just sort of highlight some elements to it, which an international audience might not be as familiar with. But our competition authorities fall under the purview of the Minister of Trade and Industry, Minister Patel, who has very openly and very expressly done several policies and intervene in several ways, which should be of a concern from a free trade perspective. For example, he has very openly said that foreign firms who want to merge or get involved in South Africa will pay a tax. He has intervened in significant international mergers, trying to extract remedies, focusing largely on international firms. He has been at the forefront of expanding the competition legislation to be more. South Africa has always included public interest considerations in merger control and our Competition Act, but he's spearheaded the expansion of our Competition Act to be far more aggressive in pursuing industrial policy, short-term objectives, hasn't shied away from intervening, has very recently proposed a localization initiative where he wants South African firms to reduce their imports or reliance on imports by up to 20%. Not so much competition law related, but it's the same minister, it's the same department, same industry, and we have seen, and 5 or 10 years ago, when we raised these very concerns about the level of ministerial intervention, about the subjective nature of public interest considerations in competition law. We've raised these on the international stage. Andreas, you and I have spoken ad nauseum about these before, and I think the international community, often just either didn't conceive of the risk associated with it, or just thought it would never play out. And the risk that we've identified 5 or 10 years ago, we are seeing come to the fore very, very graphically now. And anyone who's followed South African competition law would be very aware of that. Time permitting, we can get into the intricacies of that. But I think what I really wanted to stress in my sort of opening remarks is the level of protectionism that we are seeing in South Africa, the ability of ministers and the executive to use competition law as a tool to foster socioeconomic / industrial policy short-term gains, combined with various proposals on the horizon. For example, the recently promulgated, although not yet in effect, national security provisions, which are very broad, include grounds such as economic state of the country, economic welfare, South African consumers. I mean, you can really squeeze pretty much anything you want from an ideological perspective into those categories. And if we are not careful and mindful, and we don't ensure that we set the parameters and have the appropriate checks and balances in place, I think there is a real risk that those types of regimes can be abused by our local politicians and ministers. And I don't think it's a secret. I think they're quite open about their policies in this regard. So I certainly think there is a need, as I mentioned earlier, to have these debates, to think about how competition policy is going to be applied and adopted in the context of free trade. And I do hope we can circle back to some of these topics, because I think there's a lot to say about it. And I will close off my final remark on this and to say, well, the defense that South Africa has often raised from an antitrust perspective is that we are an emerging market. We are not a United States. We are not Europe. And therefore, we must take our socioeconomic state into play when looking at antitrust enforcement. And I think it's going to be far more difficult to defend that policy in the context of the African Free Trade Agreement or in Africa, where your counterparts are all emerging markets, essentially, are all facing many similar socioeconomic issues. So I want to pause there and sort of flag the policy debate. Thank you, Andreas.
Very interesting, Mike. And I think one of the items, if I may summarize, that you raised very astutely is a fascinating aspect that I guess every trade law practitioner needs to take into account, which is it is not only the trade regimes that we are discussing that the people on the ground really face, companies and other countries. It is also an intricate web of other laws, domestic laws that may affect trade, such as competition/antitrust rules, which could be hijacked, if you will, to affect trade. Or, as you just mentioned, national security laws, right, which exist in virtually most, if not every country, where the national security interest can be used as a veil, as a shield to prevent certain types of trade, the export of certain types of cryptography, the import or export of certain types of machinery or military devices, right? Airplanes, drones, things of that nature. So very interesting. I think we mustn't lose sight of that fact. And you raised that very astutely. I must apologize to our friend Crec, because I jumped over him in the heat of the moment. Crec, this is my oversight. Please, but I think you are, as a down on the ground practitioner, you are perfectly suited to round out this initial round of presentations. So Crec will now speak on the concept of customs valuation and trade disputes specifically in Africa. Please, you have the floor.
Thank you. Thank you very much, Andreas, for the introduction and for the good work you're doing moderating this event. I was asked to speak on the subject of customs valuation and trade disputes in Africa. And I begin by just highlighting some few facts about Africa. When you talk about Africa, we're talking about 55 member states. We have 4 official languages: English, French, Portuguese, Arabic. But when we come to the World Trade Organization, there are 44 member states of the WTO. That means we have 11 who are not in the WTO. Out of these 11, 9 are observers, and we have 2, Eritrea and Sahrawi Arab Democratic Republic, who are neither members nor observers. Africa also has the largest number of least developed countries in the world. 33 out of the 46 least developed countries in the world are found in Africa. Africa also has 16 out of the 31 landlocked countries in the world, with Chad being the largest, Eswatini being the smallest. Africa also has many regional economic communities. We have 8 officially recognized by the AU, but we also have SACU. We also have the others like the Mano River Union, which we don't hear much about. We have many legal systems. We have the civil law, we have common law, we have religious law. We also have African customary law. Actually, in some countries, African customary law appears to be superior to any other law. And to finish this observation about Africa is that we operate on 6 different time zones, from Cape Verde on the Atlantic to the islands in the Indian Ocean. When it comes to laws on customs valuation, again, most of the time we assume that the prevailing law is the agreement on customs valuation. But like we have observed, we only have 44 member countries who are members of the WTO. And so in these 44 countries, at least in theory, we have the agreement on customs valuation being applied. In reality, we have other regional laws. For example, we've talked about SACU. We have the EAC, ECOWAS. There will be regional laws also. And the good thing is that these regional laws will most often be based on the WTO. But there are also two other categories of customs valuation laws that are operating in Africa. One is the Brussels definition of value, BDV. Brussels definition of value is a valuation system that was developed by the World Customs Organization in the 1950s. But many countries are no longer using it. But there are some countries in Africa who are using it still. And lastly, we have national laws, which don't need any valuation. And an example is a law in Somaliland, which just gives a list of items and amounts payable as duties and taxes, which means you don't actually need to carry out any valuation work. So in Africa, there is quite a variety in terms of valuation systems that are in place. Regarding the agreement on customs valuation, we know that it's supposed to ensure uniformity, certainty, fairness, neutrality in customs valuation, predictability in short. But the reality on the ground is a little bit different. Africa has a large size of the informal sector, and yet the agreement on customs valuation assumes that importers will take responsibility for the valuation of their goods or to provide the correct information. And many of the players in the informal sector are simply not able to provide that kind of information. There is also widespread fraud and smuggling. In terms of traditions of customs, there is a preference for frontier checks and additional road checks due to inadequate post-clearance check capability. In terms of post-clearance audit units, they are established and effective in some countries. In some other countries, we don't have post-clearance audit units which are operational in a similar manner so as to ensure that the agreement on customs valuation is applied efficiently and effectively. In terms of organizational structure also, application of the agreement on customs valuation usually assumes that there are organizational structures, for example, for appeals, in case there is appeal. But the working structures for independent appeals are established in some countries. I'm aware of Kenya, Lesotho, Uganda, Zambia, but there are also some countries that don't have appeal structures, especially for alternative dispute resolution. We're talking about appeals tribunals instead of people going direct to the courts. And actually, a country like, for example, Nigeria does not have an administrative appeal tribunal for customs matters. It only has for tax matters. And lastly, the reality in most African countries is that customs valuation is seen as a way of collecting revenue and not facilitating trade. So the balance between trade facilitation and revenue collection is difficult for many African customs administrations. So customs valuation can actually be seen as a non-tariff barrier. It can be used for other motives other than to ensure that the value for customs purposes has been developed in accordance with the agreement. And there are problems in many African countries when it comes to valuation, because although most African countries who are members of the WTO, they are using the agreement on customs valuation, it is not being applied the way it's supposed to be applied in many countries. And this leads naturally to disputes. And these disputes that we are talking about, initially, they would be raised at the agency level, they would be raised in customs, and you would expect that somebody would raise this dispute, for example, in the area where this happened, whether in a customs office or at the border. And then, of course, this can be escalated to the regional level or to headquarters. This dispute can also go to the appeals tribunal, where such tribunals exist. And then eventually, this can end up in the courts of law. And there are cases, I know in some countries, where valuation issues have gone all the way to the higher courts of the different countries. So what are some of the issues that have actually been entertained in these in the tribunals as well as in the courts of law? Sometimes there are technical issues like the method of valuation that has been used, where you find, for example, the customs not using transaction value because they suspect that the information they've been given is not accurate and they decide to use other methods. They have raised issues like customs demanding duties and taxes beyond the statutory period. They have raised issues like where customs considers the value that has been given as being low and raises the value to avoid unfair trade. And there have even been other cases where customs has adjusted the sum for insurance. So when you look at the record of these cases that you find published, which is a very good thing. I've seen published cases for Kenya, for Uganda, for Zambia, and a range of issues are being raised as being disputed by customs, as well as traders. And looking forward, I think we can expect rising litigation. I think somebody mentioned about the few cases that have been taken by African countries to the WTO, whether it is an issue of trade remedies or even other areas of WTO law. But within Africa, at the country level, even at the regional level, we are seeing rising cases of people using administrative appeal mechanisms, like the tribunals. They're using the courts, national and regional. And I would expect that the AfCFTA dispute settlement mechanism that is established by the Protocol on Dispute Settlement may actually be quite busy over time. We also expect customs administrations will be expected to apply the customs valuation law strictly and not bend it because of revenue concerns. We see that appeals tribunals are becoming more and more independent. They are not seen to be under the control of either the ministries of finance or even customs. And lastly, I think training and capacity building is important, but more important than training and capacity building is actually having the right structures like the appeal tribunals. Thank you very much, Andreas.
Thank you, Craig. That was a whole lot of practical advice, and I'm sure everybody here has learned something about some area they were unaware of previously, even on the panel, and I hope in the audience. Correct. I think one of the items you raised about the timing of these customs disputes and taking them to an administrative appeal or review board, then potentially having litigation, potentially going all the way to the National Supreme Court, strikes me as something that is nice in theory, but sometimes in practice entirely impracticable, right? Especially if you have a perishable good that's sitting in a container or on a ship in 500 containers, strikes me as impossible. You know, the trader simply does not have time to take a matter through, you know, months of litigation and appellate procedures when the bananas or the milk or the oil is going bad inside the tanker. So some of these things, I'm sure you mentioned extortionist practices can be, there's extortion going on. So there are these extrajudicial, extra legal measures that complicate matters yet more. Mike raised the issue of non-trade laws, such as competition laws or national security, national interest laws. You raised the issue of religious law and essentially informal trade, smuggling, and extortion by border officials or customs officials. This makes everything very complex, in addition to the complex legal instruments of the AfCFTA and WTO and other trade blocs that were raised earlier by Professor Erasmus. If I may take it back, and after that, I will simply open the floor to you all. If I may take it back to our first panelist, Vasilis. Vasilis, you're mostly an EU and global worldwide practitioner, but what has struck you so far on this panel with the focus on Africa by these African situated experts as something that is striking to you?
Well, good question. I think what Mike said about politicizing, the risk of politicizing trade remedy instruments. And indeed, that is a risk. I think one shouldn't lose sight from the fact that, firstly, trade remedies are not counteracting an illegal practice, right? So it's not like in a cartel investigation where the authority is chasing conspirators that go to jail and fines are imposed. The duties are not, the trade remedy duties are not a fine, right? They are duties that aim at counteracting an unfair trading practice, right? And there's always two parallel fights unfolding in a trade remedy case. One is between the petitioner, domestic industry, and the respondent exporters in the targeted country. And the second one, and perhaps equally important, is between the national industry, the domestic industry, the petitioners, and the domestic end users who don't want duties. So as a regulator and as a government, I think the focus should be on societal welfare. What are we doing here? Why are we imposing the duties? Why are we initiating an investigation to start with? And then balance out all the interests of the parties involved. But to do this in a fair fashion, because I have seen authorities, and I don't want to name them now, who are more political, so to speak, than others. And the outcome is, I think, not good for their society. You may have whole sectors of end user industries in the domestic market that will suffer enormously from a long-term imposition of duties. So these investigations have to remain highly technical, and they are highly technical. I mean, those of you who had the questionable pleasure in being caught in an anti-dumping investigation, even more if it's a complex one, like with several related companies, different product types, and all sorts of allowances on the prices and the costs and the allocations, will know how difficult it is, how demanding it is at a technical level. Now, if an authority or a government wipes away, the technical aspect of this and imposes sort of a more political stance towards imposing measures, whom to target. And I will say a few things about China, the elephant in the house, as you said. Then the outcome would not be good for their society, right? So how to achieve that? I think through constant pressure to the regulator to improve technically, to remain at technical level, listen to the respondents, listen to the users to achieve a fair, balanced outcome. And also perhaps by creating specialized chambers in tribunals, in whichever tribunals the trade remedy orders are being challenged in each country. Right. There's nothing worse than trying to plead an anti-dumping case before a judge who knows absolutely nothing, who doesn't understand what this is about. This is terrible. While a judge that understands what's happening, understands what are the mechanics of this, as I said, is highly technical. I mean, in our team, in the office, all of the lawyers are very conversant with accounting. They all manage data, large volumes of data on their laptops. They handle databases. They're capable of talking to the chief accountants of companies and then talking to the regulator, challenge their findings, or help the regulator get to a fair result, right? That is a very important parameter of the investigations. That is one thing that struck me. Another one is that what Alice said about new rules being established in Africa regarding the duration of the measures, because Alice, you spoke about safeguards. and you said it's 4 + 4 maximum years, but I think you also said that this is the, unless I'm mistaken, the maximum duration of also of anti-dumping and countervailing duty measures. That would be a first, because I mean, in other countries, an anti-dumping order may remain alive for 25 years. They may be renewed every 5 years, forever. Coming to China, yes, China is the elephant in the room. It forms the biggest, by far the biggest threat to domestic industries for a number of reasons. First of all, due to its sheer size of industry. Many of China's industries suffer from structural overcapacity that pushes exporters into a cutthroat competition between them in China, and it results in even lower prices in the country of exportation, causing even higher injury to the domestic industry. And it's also the industrial plateau of the world. So it's very difficult to stop importing from China. And very difficult also to withstand competition from China. So how to tackle this? Well, the EU has come up, you may have heard about the never-ending discussion between market and non-market economy countries. In the Chinese accession protocol, the WTO, China's accession protocol, there was a rule that other WTO members could consider China as a non-market economy country for quite a long time, 15 years, but then it was over. So what did the EU do? The EU, and I think that several other jurisdictions, for sure the UK, which after Brexit now has its own trade remedy authority, are looking into establishing an EU-like system. The EU established a new system 3-4 years ago, whereby it does not concern specifically China. It may concern any country where government action results in significant distortions, market distortions. What are these market distortions? Well, I would say any effect on the market which is not the result of supply and demand.
Right.
So I think that this is the way that the African regulators should also follow.
Thank you, Vasilis. I think one of the points you just raised is interesting regarding the actual end user. We have not talked about the average person in country, right? Who is actually affected by tariffs? And sitting here in Washington, D.C. in the United States, I have lived through this with the last administration that shall not be named by name, out of shame. And, the imposition of these unilateral tariffs on Chinese or European imports. And there was vast community support of the political base of the last administration for these tariffs. Yes, let's impose a tariff. That is great. And of course, as trade experts here and the attendees who are listening, everybody here understands that ultimately this will be passed down. This extra cost will be passed down to the lowest common denominator, i.e. the end user, who will pay more for the same product. So that is what was not understood, I believe, by a vast swath of the population. And just these basic functions and effects of, I think, things such as tariffs and other trade remedies are still misunderstood. And perhaps, I think somebody mentioned, I think it was Crowell who mentioned the concept of capacity building. Not only do we need to build capacity and capabilities and best practices within the agencies and within the expert regulators, but perhaps also do a generalized educational program that affects really the entire populace. And in Africa, that could perhaps be done under the auspices of the AfCFTA, that there are, sort of public relations pushes within journalism, reporting, public interest groups, community groups that can explain the benefits and the pitfalls of free trade within Africa. I think Peter has a point to make.
Yes, thanks, Andreas. Thanks, Vasilis, and thanks to everyone. I think there were some super presentations. This is where I guess somebody who has a little bit of economic background comes right into the picture. And I'll be very, very arrogant and say that I have a tiny bit of that background. When I was studying international economics at the University of Chicago, we always put the focus, as indeed most of the trade theorists over history have put the focus, on the issue exactly that Andreas has just been underlining, namely something called consumer welfare. The whole point of the game was precisely, and is supposed to be, that end users, whether they're consumers like ourselves around this table or this screen, or whether they're industrial consumers, that they should be able to get what they need at lower prices and at same or better quality. That's always been the core of the game. And that's why trade per se has been advanced as an important thing, a very important thing to do. So I couldn't agree more that to a major extent, that's been lost sight of, or at least it's been drowned. It's been drowned in a massive campaign of either disinformation, ignorance, call it what you will. But I also want to link this with what's been happening, and I think is happening a lot in Africa and has been happening elsewhere, and hits back and comes into some of the earlier points also raised by Vasilis and by Mike. Quickly said, in Europe, we've seen a tremendous development of social groupings which have exerted enormous power over the last few years. Take a core initiative that was put forward by the EU when Barroso was president, along with the US administration with Obama, the so-called TTIP, the Trade and Investment, the Transatlantic Trade and Investment Pact. That got blocked. And if somebody didn't like it being blocked, then I have to say that I'm one of the persons responsible for that. We organized a massive movement pointing out that there were so many things in this that we considered very, very dangerous for European consumers, including, for example, food standards and heaps of other things. But to link that with the earlier points, it was a trade and investment pact. Nobody nowadays, and for a very long time, talks about trade alone. You talk about trade in relation to all sorts of other things. For example, the South African Institute of International Affairs has produced quite recently an extremely interesting paper for the South Koreans on how does all this trade stuff with AfCFTA link in for Korean investors. Trade and investment linked together. Now we're in a position, in my view, where I would simply say there are four things that now dominate the game: trade, investment, national security, and human rights related considerations. These are now dealt with together. They're something that cannot be separated, things that cannot be separated. We're in the epoch where certain groups are trying to push the national security thing. Other groups are trying to push other angles. So I think I do have more to say on this. I'll stop here, but I think this is what I meant earlier when I made the comment about the kind of wholeness of the issues that we've got to look at here.
Right. I think that's a fascinating summary and a fascinating addition in it, indeed, of these four factors. And if you include, and I'm not the expert here, but if you include within the last block that you mentioned, i.e. human rights, if you include ecological/green issues
Absolutely.
in that block, that probably, otherwise it would be probably a fifth element that is becoming clearly much more important these days. So I think that's a good point. We are somewhat running out of time. We have about 6 or 7 minutes left. I see two virtual yellow hands. This seems to be the universal skin color here of the emoji. We have two hands up from Krek and Tuto, and I would like to have them speak. And then I have one question for Professor Erasmus, but let's start with Tuto, and then Krek, and then hopefully we can limit our comments to about 1 minute to 2 minutes, and then I'll ask Professor Erasmus a final question. Tuto.
Thanks a lot, Andreas, and to our fellow panelists. Clearly, we have provided very little time for this. I think there's a lot more interesting discussion. So I just wanted to jump in to say, of course, in SACU, what we have also seen a lot of dynamics, for example, in relation to the which countries come into play, and also which products we see, the likes of the US, some European countries, and China, obviously. We will pop up there when you're starting to talk about these things. In terms of products, you hear about chicken, some steel products, textiles, and so on. But just maybe to tap in a little on the issue about I think there's some discussion that went on relating to impact, perhaps, just to say that there's another aspect that I found interesting to say that sometimes ITEC undertakes an impact study following a measure that would have been done, for example, an anti-dumping duty. Quite an interesting dynamic came up in one of the measures that was taken on anti-dumping, whereby certain blankets from China, where there was an anti-dumping on that. And then they were looking at the impact at a later stage, only to find that there has now emerged a new closely related product that now is starting to penetrate the market, because the impact was being looked at in the context of the likes of employment, domestic production, whether it's increasing, investment, such other things. And now there was this new dynamic, which has now diverted the whole issue. And perhaps then the industry that was being protected in the first place was now not receiving the impact that it should have. So this brings out a lot more in terms of, things can change along the way, and this kind of investigations take time. What then needs to be done to make sure that at the end of the day, we are improving the welfare of people? Thank you. I don't want to go long since we are already out of time. Thank you, Andreas.
Thanks, Tuto. We also have one question, by the way, but from the audience, but I will pass it on to Craig first for a minute of his comments.
Thank you, Andreas, and I'll keep it actually to a minute. I think one of the things about trade remedies in Africa, the biggest challenge is that we don't have trade remedy institutions. Apart from South Africa, and I think Alice mentioned Egypt, which is carrying out investigations under the Ministry of Trade. Then we have Morocco also having a unit within the Ministry of Trade. There are only 3 other countries that have trade remedies authorities, which are independent, specialized trade remedies institutions. We have Ghana, Madagascar, and most recently Kenya. So the absence of trade remedy institutions makes it very difficult for any trade remedy work to be done. And so they use other ways of addressing issues that would have been addressed by trade remedies, sometimes by just taking unilateral action to block imports. Thank you, Andreas.
Thanks, Craig. Professor Erasmus, one question that has popped up is, if you can speak to this, in investigations that you have been involved in through Tralac, the level of capacity and evidence and data, I think it came up in Vasily's point about the vast databases that are sometimes necessary to investigate these trade disputes and to analyze them, and to have to use experts in accounting and economics, etc., both micro and macro. Can you speak to that in the dispute resolution context, what the role is, or what your experience has been in relation to that type of evidentiary data?
I will mention 3 factors. The first one is, Craig is correct. We have only 2 active users of anti-dumping and countervailing and safeguard, of trade remedy and safeguard disciplines on the multilateral level. historically Egypt and South Africa. So park the one main institutional deficit, technical capacity, and everything that goes with this complicated area of law. Secondly, trade data. Where is data being captured with respect to imports and exports? At the customs level. And then, of course, the statistical offices. Trade data is a major issue. Third problem is our governments never litigate against each other over trade issues. I cannot think of any case in a regional economic community court or tribunal where one government has tackled the other one about a trade issue. So the summary on this, on the conclusion on this point is, we have a long way to walk in order to be a properly rules-based trade dispensation, where you take the availability of domestic remedies, due process remedies, and you take them onto the regional and the international and the multilateral level. And these are the three factors. And then when we look at some of the other related ones, and they are related, China doesn't enter into trade agreements with African nations. There are one or two here or there. So the overall construct is not conducive enough to a proper rules-based dispensation. And therefore, many of the good things that can be had that we have heard from Vasilis, they are institutionally difficult to have. That's it.
Very interesting, very interesting.
And also low levels of industrialization, remember that. If you have low levels of industrialization, the scope for trade remedies will by definition, and subsidies of course too. So we're talking about a very sui generis regime.
Right. I think one of the elements that has to be taken into account here, and I'm not sure if we've really touched on that except for Peter's mentioning of the overall statistics of intra-African trade at the beginning, one of the important elements is, of course, the nature of the average African economy. As you just pointed out, Professor, low levels of industrialization, a large skewing of the import versus export concept, right? If you look at the numbers, Africa imports a lot of manufactured high-tech goods. We spoke about the value-added chain. Again, I'm not an economist, but I understand what is meant by that. And I think that, of course, skews the applicability of certain trade laws and trade remedies as well. One of the questions that are pending, and I know we are pretty much at the end of our fascinating panel, one of the questions is from Barney Sultani, who asked, what were the 5 considerations again, please? I think this refers to what Peter said. And if I can summarize, if I remember correctly, it was trade remedies, it was foreign direct investment, it was national security, and then human rights and or other concerns such as ecological, carbon neutral, et cetera, et cetera. In conclusion, we are a few minutes over, but we started a few minutes late, so I think this is perfect. I think what I would like to propose, and if we get agreement from the audience, we still have a large number of audience members with us after 90 minutes, which is a good sign. So I take that as an implicit and silent yes. I would like to actually continue this discussion at some point in the future, perhaps before the end of the year. Because I think there are lots of items that have remained only touched on the surface. I don't want to say unsaid. I think we said a lot. We conveyed a lot, and I learned a lot for sure. So I hope everybody else feels the same way. I hope the panelists learned a little bit as well. We never stop being students, of course. And I hope that the audience also benefited from this webinar. We thank everyone. And with that, I will conclude this webinar. It will be saved. We recorded this, so it will be accessible on the Primerio website. And to the extent that others would like to share it, we will provide the link as well, and they can host the video and the audio of this as well. I'm glad that there weren't any technical glitches. I'm glad we were able to answer questions, and I hope we had an equitable distribution of time for everyone. Thank you all.